you have to pay the other side's fees. That can be often a galling prospect to someone, especially when you're litigating against a close relative, a brother-in-law, a cousin, something like that. Another thing that can happen is that the court can appoint a receiver in cases of deadlock to run your company for you. The court can also order a dissolution of the company, or it might also order one side to do a forced buyout of the other side. These can all have big problems on the business, and indeed can often destroy the business. Now, the good cop approach to it is that there are ways that you can manage these things. You have to recognize that conflict in the family business milieu is unavoidable. There's always going to be problems. Every family has their own dynamic. And if there's stressors like in this economy, there's problems with the business, there is going to be conflict between people as to how to run the business. This is just human nature. The goal that you have to have is conflict management. You have to head these things off at the pass, or as I say in my outline, as Barney Fife said, you got to nip it in the bud. So the way you do that is you have to, first of all, have good agreements, have a written plan. Now, Chris talked about plans about restrictive covenants. Phil talked about buy-sell agreements. You have to have everything planned out in writing. Now, this, I can't go into all the topics because it would take us another 2 or 3 hours to say exactly what you need in your agreements, but I have it in my outline. You have to have a plan, a written plan addressing these major issues. So if it does come to litigation, there is something that you can point to, and you're not just talking about what he said at a meeting 10 years ago, what he said at this other time, something that's not documented at all. If you have it in writing, it's something that a court can use to rule on your case, and it can minimize the disputes, minimize the time and the effort it's going to take. Now, another thing that should be done is to recognize you should have an interactive process and a proactive process. That means instead of letting these disputes bubble up and cause problems, letting them fester, get them out in the open. What I would recommend is having regular meetings. Anybody who's involved in the business, he's a family member, he's an employee, he's an owner, he's in the management, have regular meetings. If there's issues that are coming up, bring them out, talk about them, get them out there. This can often have a good effect and minimize the hard feelings. Now, sometimes that doesn't work. What you want to do also is to have in your agreements a provision for alternative dispute resolution, which we lawyers call ADR. And it's a big buzzword, but basically you have a method where you go and you have an individual call the shots on it rather than the court. So you have a licensed arbitrator or mediator. We have Judge Camp from our firm is over there. He is a retired judge from the Superior Court. He does a number of mediations and arbitrations, and he is excellent at bringing people to agreements and mediations and ruling on cases in arbitration. But the point is, if you have a provision and it's clear in your agreements, you can have a provision which would establish a process where you would have a faster ability to resolve these disputes. So the arbitrator you don't have to go to court, you go to an arbitrator, or if you do it in his office, and often that's a lot faster to do and less expensive. Now, sometimes you can't get agreement to have ADR, and sometimes these proactive processes don't work, and you have to have litigation. When you go to litigation then, my advice is to be prepared. And like the New York lottery says, you got to be in it to win it. So when you go, you have to say, okay, well, gloves are off, I'm going and I'm going to litigate this case. But you can't lose sight of the fact that you want to be civil. I mean, we lawyers love talking about civility, but the people who have to be civil are often the clients, because a court is going to look on it negatively if you're the one constantly carping, saying, okay, well, this guy did this to me when I was 10 years old, or bringing up old family business. You know, he took my bike, my father gave him a better present. you got to put that aside. You got to approach it as a business proposition and put the emotions aside. So you want to keep focused on it and keep focused on what the dispute is that is bringing you to the court, or if it's an alternative dispute resolution situation, what's bringing you there. And again, I would stress that, as Phil, I think, said, that it's a team effort. You have to have cooperation between all types of lawyers who are, transactional lawyers, lawyers who are especially into restrictive covenants, and litigators. And that's how you really should focus on it. And it's a team effort, not just between the lawyers, but between lawyer and client. So there really should be an interactive process between the lawyer and the client as well, in order to discuss these issues and make sure you know what you're getting into when you have a dispute, and have ways to avoid it or maximize your ability to succeed if it does go to litigation. Thank you.
Okay, if anyone has any quick questions, we'll entertain a few. Otherwise, our attorneys will be here for a little while, and you can have a direct question and answer with them if you choose. But any questions out there? Okay, I'd like to thank you for coming. Again, I want to thank Dean Moore and Fairleigh Dickinson University and the Rothman Institute. I know it's been a fun thing for us to put together and get all of you here this morning. And we hope we can help you with your legal problems in the future. And thanks again for coming, and have a great day.